I'd say that the top takeaway for lawyers working in disaster recovery is to recognize if you're working with a person with a disability. So sometimes that's going to require asking a question of someone who you suspect may have a disability. Maybe you recognize that they're elderly, that they use a cane. Ask a few follow-up questions. Find out, do they happen to have any other kind of memory impairment or cognitive impairment? And if so, that gives you another way in your advocacy to use the tool of requesting accommodations. So it may be that that person missed a FEMA appeal deadline, but knowing that that person has a memory impairment gives you a basis to say, my client has a disability. As a reasonable accommodation to their disability, I would request an extension on the timeline to appeal the denial of their FEMA benefits. So the first is just recognizing that the person has a disability and then using that to request accommodations. Something that lawyers can do to make sure they have a positive client experience when working with people with disabilities is first to remember that it's okay to talk about disability. Two, to remember that they should still assume competency when talking to a person with a disability. You may recognize that a person is stuttering or speaking differently or even using assistive technology, but you should still assume that you can talk to that person about their case until you figure out otherwise. And so I think sometimes there can be a hesitancy to engage with a person with a disability because they communicate differently or they look different. And so I think the first thing lawyers should keep in mind is assume that they can still have a regular lawyer-client relationship with that person until the opposite's proved. So when attorneys decide to help in disaster legal services for people with disabilities, probably the first thing they have to keep in mind is that persons with disabilities, even more than others, need support doing things that can seem like basic skills. And so for a lawyer, it's obvious to put things in writing, to put a request for accommodations in writing, to document repairs that need made to their apartment or to their home. But for many people with disabilities, those are things that they would usually do in an oral conversation. They don't know how to document those requests or need help just writing a letter. So really, any lawyer has the basic skills that are needed to contribute positively to advocate for people with disabilities, because the first step is almost always helping that person put their request in writing, request that accommodation, notify the landlord in writing of the conditions that they're living in, request that reasonable accommodation from FEMA. A lot of this comes down to just a willingness to serve and an ability to write a letter. For attorneys who are wanting to help people with disabilities or understand the legal rights of people with disabilities, there's a powerful network, the Protection and Advocacy Network, and an organization that's a member of that network exists in every state. And I work at Disability Rights Texas, which is the P&A for the state of Texas. Each P&A has a lot of resources and advocacy tools on their websites that are specific to the rights of people with disabilities in their state. So it's one powerful resource anywhere someone lives to understand the rights of people with disabilities in their state. We're going to start with some kind of overarching kind of principles around representing people with disabilities and just understanding the big picture. And then we're going to move into some substantive training on the highlights of both healthcare as well as housing. But I think the most important thing that I realized wasn't in our PowerPoint is the intake number for our hurricane project. And the reason I say it's the most important is because I don't expect anyone to attend today and become an expert on disability, and we're not going to try to make you an expert on disability. So if you encounter a tough disability-related issue, or you just want to staff a case for a person with a disability that you're wondering if there's a legal solution to their problem, feel free to just consider us that resource within that network. And so our Harvey hotline is 1-800-362-2851. Again, that is 1-800-362-2851. For those of you who aren't familiar with Disability Rights Texas as an organization, we are a protection and advocacy organization. So every state has a protection and advocacy organization to serve people with disabilities in their state. It's much like legal aid for people with disabilities, except we don't have the class action restriction. But that's essentially who P&As are. And so for those of you in Florida, conveniently, your P&A is called Disability Rights Florida. So most of us are disability rights state names, with a few outliers with more unique names. And so know that that's a resource. We've been around since the 70s. Each state gets to pick what issues they tend to focus on, but there are some common trends where in almost every state, we handle a lot of issues related to education, matters of discrimination, institutional rights, whether it's in psychiatric hospitals, jails, facilities for people with intellectual disabilities, and then usually healthcare appeals as well. So those are kind of core areas that you would usually see in every P&A. Also disputes with the vocational rehabilitation system. So that's the system that you would utilize if you have a disability to attempt getting support, getting a job. And so for people who run into barriers with that system, there is a program in every state to help navigate those barriers. So now jumping into a little more substance, and I think I know this will be remedial for many of you, but I am aware that some of you have probably never thought a lot about disability issues. So for those of you in the room, the first thing is always, how do we talk about disability issues and what language do we use so that at a minimum we're not offensive in the panel we're about to engage in. So I'm going to ask my colleague my colleague Jean to just introduce the topic of kind of what are some best practices to keep in mind when we talk about people with disabilities and their need.
Thanks, Dustin. One of the things I think you'll find, and some of you may have an individual in your family that has a disability, so you may be very familiar with some of the issues facing an individual with a disability. The first thing we like to have people understand is it is about the person. So we refer to it as person-first language or people-first language. So it's not the autistic child. It's not the quadriplegic. It's not you do not define them by their disability. It is a matter of a child with autism, an individual with quadriplegia, or an individual with a mobility impairment. So I think as far as that comfort level goes, and I speak from experience, although it's been like 35 years ago, I had background working in community organizing and neighborhood organizing, and I applied for a job with an organization called the Coalition of Texans with Disabilities. Knew nothing about disabilities, but I knew about nonprofits and I knew about bringing people together. So I interviewed with a group of people with all kinds of different disabilities, and they asked me, questions like, how would you communicate with somebody who's deaf? I was honest and said, I don't know. And they ended up hiring me just because I was honest. So the first thing I would recommend is just be yourself, be comfortable, and ask the questions. But remember to think about the person first. And then they'll be comfortable, the individual will be comfortable, you'll be comfortable, and it's a matter of how you treat people. It's not, and I hear this a lot of times, especially in our current environment, oh, you're being so politically correct. And it's like, no, these are about the individuals, and we're talking about being respectful. The use of the R word, we don't use the R word anymore. It's a person with an intellectual disabilities, and people will be critical and say, why are you being so politically correct? Oh, come on, I'm just joking. No, you're not. You're describing an individual in a negative way, that there's no reason to do that. So, I mean, if you just think about it, and if you think of the individuals that you know that might have some kind of disability, if you approach it from that perspective, you'll be comfortable and they'll be comfortable.
And I think so much of that history of how language was used before the People First movement really comes from a place of the bias and stigma that those disabilities have. And one thing that had always stuck out to me as an example is that you would never hear of someone without a disability, but with a health issue of being seen as she is cancer. You would say, well, she has cancer. But then with other impairments and disabilities, you tend to hear that person is bipolar, or that person, is their disability category. And so that's what people don't like. And so it's good to just try to lead by example. We're always in our work advocating in systems that don't use the preferred language, but that doesn't mean we should adopt their language. We should have them adopt ours, of course. So, one thing to recognize about disability too, and just in those basic interactions, is you'll notice that one thing that Jean didn't suggest is just speaking louder at the person who is deaf or has a different kind of disability. And when we talk about that, that may seem really obvious in a room like this. But when presented with someone who's different, a lot of times you may recognize that people have all different sorts of disabilities. So what is a disability? Well, it's everything from a learning disability to ADHD to depression to deafness or visual impairment. So it's really a very broad category of impairments that affect, major life activities. And because of that, the accommodations that one person needs are going to be very different than the accommodations that someone else needs. And so when in doubt, ask that person. And I think the principles around communication, first and foremost, don't assume that the person doesn't have capacity. So it's absolutely true that you may, in your work, need to work with an individual with a really significant intellectual disability who's not able to communicate their thoughts and wishes with you. It's also true that you may work with some people with disabilities who are absolutely capable of having a conversation and understanding legal advice from you. And what you don't want to do is just assume that the person doesn't have capacity or abilities just because they communicate differently or have some kind of impairment. So I want to ask the attorneys here, so Taft and Jennifer, to both just speak about some practical tips in representing people with disabilities. And that can be, really whether it's rapport building, client relationships, something that maybe you just recognized was different than other service work you've done in the past.
So to launch off of what Dustin just said, touched on briefly, presume competence, presume that they can understand you. You don't want to use legalese just like you wouldn't talk to someone who didn't go to law school and use big court words or terms of art. But you also don't want to talk down to someone, because even if they're using maybe assistive technology to communicate or sign language or whatever, they are likely able to understand everything that you have to say to them, and you should presume that they do. And if you can always lead off with, if I need to repeat something or clarify something, just let me know. But presume competence first and foremost, because most people don't get a whole lot of respect elsewhere, and they should get that from their attorneys. It's also like when you're using assistive technology or say an interpreter, speak to the person. Don't speak to the device or the interpreter. You're speaking to the person that you're serving, and then the interpreter can do the rest. I don't know if you guys have done that with language or sign language, but that's also highly important. The person that you're talking to is competent, and you should look at them and speak to them. Taft?
Something else is you need to be patient. A lot of times they come to us because no one else is listening, and we just take the time out to listen. A lot of times they call FEMA, they're not listening to them. They call 211, they're not listening to them. They just want a disaster case manager, and instead they send them on a wild goose chase because they didn't listen to anything that they said. Sometimes you just have to take a little bit of time out of your day and spend the time with them that they need in order to get what they want out of the conversation.
On top of that, with patients, again, with presuming competence, some people may communicate at a different rate or may process even at a different rate, so they can understand everything that you're saying to them, but they might need you to repeat it more often or speak a little slower. And that doesn't mean that they're not competent or that they're not perfectly intelligent. They just need you to go a little slower or repeat yourself from time to time, and that takes a lot of patience sometimes. Sometimes it's kind of fun.
One of the other assumptions that I think that we have to just make sure that everyone who encounters people with disabilities in disaster work understands is that a huge part of the disability civil rights movement is around deinstitutionalization and allowing people to live in the most integrated setting. And so there was a time in disability history, not so long ago, where it was assumed that especially people with intellectual disabilities were going to be put in institutions and live there for the rest of their lives. The origin of the P&A network that we're all a part of is that in the 70s, the conditions, the abuse, neglect, and the unnecessary deaths in those facilities became known to the public, and Congress passed laws for independent organizations and watchdogs to help people be treated fairly in those places and whenever possible to get out. And it is now an illegal form of disability discrimination to unnecessarily force a person with a disability to live in an institution, whether that be a nursing home or any other type of congregate living situation, if that person's needs can be met in a community-based setting. Kind of despite that history, what we continue to see is that when people aren't thinking in those terms, and you're dealing with emergencies and disasters, people can be unnecessarily institutionalized. Rights can be infringed. People can just talk to someone's relatives and not take the time to do what Jennifer and what Taft were suggesting of how you should really kind of treat your client with a disability. So I want to transition now and let Jean talk about kind of the big picture. What are the policy issues in disaster recovery for people with disabilities, both with FEMA at the state level? What are the issues that she's seen at that level? And Jean, I'll let you come up here so you can cursor through your PowerPoint, and we will keep time for everyone at the end for questions and wide open on any disability-related topic.
As you can imagine, one of the largest issues that we face is related to where somebody lives. And the reality is, prior to any kind of disaster, there's still a shortage. There's a shortage to begin with of affordable, accessible, and what we would refer to as integrated housing for individuals with disabilities. So before the disaster hit, we have this issue that we continuously have been working on a policy level to try to increase the number of affordable, accessible, and integrated, not only apartments, houses, and other living arrangements, but also in the area of services. There's limited services available to allow individuals with disabilities to live in the community. And then the reality is many people with disabilities are receiving Social Security income, and so that's considered a low income in many, many areas. In some very rural parts of Texas, it's actually above the poverty line, but those are very, very limited anymore. But you're looking at individuals that have a limited income to begin with, and then impacted by a disaster, you're going to have additional problems. And then without any kind of better and improvement in these supports to live in the community, it's a barrier from the beginning. And then, on top of that, when you have the impact of a disaster, the things we work on policy-wise at the state legislature, at the various state agencies, is to, during our legislative session, and in Texas, we only have that every 2 years. I'm not sure what Florida has, but some people are very thankful we only do it 2 years in Texas, just because of the damage that they usually do. But we work throughout that time during the legislative session from January through May. And then all that other time, we're working with state agencies and looking at the rules and the programs, and they're constantly updating rules. They're constantly updating the way that services are delivered. In most cases, they're cutting back, at least in Texas. They're looking at ways to trim the benefits, cut back on the money that's being spent. So as advocates, we're there to try to speak with, alongside many individuals who are self-advocates, are there to talk about their life experience and how they want to live in the community, and what they need to live in the community. So that's what we have on an ongoing basis. Then you have the impact of the disaster, and it quadruples the issues that are faced by individuals. Let me see if I can go, wrong way. In talking about people with disabilities and the overall poverty rate of an individual that's receiving disability benefits, the poverty rate of a working age person with a disability, or in Texas anyways, it's 23.7% as compared to the 11.9 of the general population. So, I mean, just the statistics bear out the problem and the issues and the challenges that people are facing. In the affordability end, as far as looking at housing, there is an organization that works on a national level and looks at every state and looks at what the disability, general disability payment would be monthly, and then what the rent is. In Texas, there's no affordability. I mean, you need the public benefit, you need the assistance of housing vouchers and other supports, which, as we all know, are very limited. So these are I just wanted to give you all the broad overview to understand for the individuals with a disability, what they're faced with if they're receiving those kind of benefits. They're twice the percentage of their income would be used towards rent. You know, twice of a working age individual who does not have a disability or is not receiving benefits. As far as painting the picture of what it was before the disaster, and then you have the impact of the disaster on individuals. And we were involved from the beginning, as many of the legal aid organizations were, and involved in statewide calls almost on a daily basis to talk about what kind of issues there were. I mean, be it in education, be it in the housing situation, the loss of, when you think about an individual or a family that has a child with a disability and they're attending their neighborhood school, and then that neighborhood school is gone. And so all those supports that they have in school are gone, and individuals are directed to other schools. There are many cases they did not receive the supports that they needed to remain in school. So you have, you know, all these impacts happening at the same time. In the housing arena, we lost many of the affordable units that were there, or the accessible units that were available were impacted. And so there was a situation in Houston with the high-rise, the 2100 Memorial, where individuals who were elderly but also had disabilities, or had a disability and were not elderly but were living in there, and then suddenly they're going to shut it down with like a 3-day notice. You know, all of these things, when you're impacted by the disaster, they have ripple effects from now. I mean, there's individuals now that were moved to other places, but their home is still where originally they were now, you know, almost a year ago. What our effort has been now is the state and the city of Houston put together their plans, or they have put together their plans in response to the disaster to get that community development block grant recovery money. Each of those have to put together plans. And what our work has been to be involved in responding to those plans when they're put out as quote-unquote draft. Some of the things that we wanted to make sure was that what was going to be rebuilt was that there was the accessibility in there, in the new construction, and that there were provisions, and that they were counting the number of people with disabilities accurately. What I think we've provided to you, or we're going to provide to you, are some of the copies of the letters that we have put together to notify the state after we reviewed the plan that they didn't count correctly the number of people using the census. They couldn't even do that right. They took a little piece of the census that said anybody over the age of 5 and under the age of 65, these are the percentages that would have disability, and this is how we would then direct some of the funding. Well, they left out all of those under the age of 5, and over the age of 65, the number of individuals with disabilities really skyrockets. And it's like 40% of individuals over the age of 65 have a disability. So when our state is putting together their plans and looking at how they're going to allocate the money, if they're looking at, okay, we're counting, I think it was 7.95%, almost 8%, when in reality, if you looked at the census, and we're not making up these numbers, we're not saying, although we asked them to please use some of FEMA numbers, or please use some other way of doing some counting of the number of individuals with disabilities, they didn't. And they said, well, this is what it is. I think the one thing that we did find in this year, or this time around in the plans that were put together, is the state, through the General Land Office, put together the CDBG plan for disaster recovery, and they put it out as a draft. And so what you do, they give you 30 days. Well, actually, they tried to do 15 days, but it ended up, because of the outcry from advocates in the housing area and others, to say, what about all of these things that you've got incorrect? So many organizations send in all these public comments about fair housing, about how they didn't follow some of the requirements. And so our experience has been, over the years, when you work with organizations, that you comment on the draft and they look at what you're saying and go, oh, okay, maybe we should correct that. Not this time. What they did was they just attached everybody's comments, sent their original plan up to HUD, and HUD approved it. Didn't even say, well, weren't you going to listen to any of these people that pointed out these things? And in the area of disability, it was kind of outrageous that they overlooked some very specific things as far as complying with the Americans with Disabilities Act, as far as following 504. Didn't put any of that in the plan, and we pointed all that out to them. So we've seen a real turn in the way during a disaster. The response is, let's just be quick. Everything we do, let's be quick. And what we've tried to get them to do is to be more thoughtful and to make sure that you're covering the various populations. So it has been somewhat of a frustrating situation, but it is something I think all of us need to track and see what is happening, because the future, what's going to be built and how the response is going to go forward, is really going to be based on these plans that are now adopted. The same thing, unfortunately, the thing we learned is the state, the General Land Office does their plan, HUD accepts it, and then part of the money is given to the City of Houston. The City of Houston follows what the General Land Office does and does the same thing. So then we send the same comments, wait, you're undercounting the number of people with disabilities. It's going to impact how you're allocating the funds. So I think what we've learned is when things go wrong at the state level, at the local level, if in fact they just follow what the state's doing, that you're going to continue, kind of have a continuous problem and have to respond to it. I think the other thing, as far as trying to partner with other organizations, sometimes with those that advocate for people that are homeless, oftentimes have a different model in their design to serve people that sometimes in our world seems a little segregated. And so we try to partner as much as we can with other organizations, but that's something to consider. Sometimes the needs are not the same in the special, as the state would refer to it, as those special need populations, where they lump the homeless organizations or those that are serving homeless and those that who are homeless and need assistance are not always the same as individuals with disabilities. So we also have to spend our time pointing out the difference and pointing out the need to have programs that are integrated and can serve everyone. And as I mentioned, what our role has been to really review and analyze the plans and then provide the comments. We do collaborate with a lot of different disability organizations. And then during the interim, because the state agencies are the ones that are putting out the plans, And because they responded in the way that they did, to not consider some of the proper percentages, to direct some of this money, to make sure that there's accessibility. The other end of it is to go to the legislative branch, who does have the hearings and other things, and to make sure we're there also to point out the needs and say, wait, your state agency that you oversee over here that's putting together the plan is overlooking the needs of people with disabilities. So there's a great need for advocacy. I know many of you all are with the legal aids. I know in Texas we partner a lot of times with Rio Grande Legal Aid at the state level to make sure that we all are coming together as much as we possibly can, because the voices, the more you can get together and the louder you can be, the more opportunity you're going to have those that are setting policy listen to you. So, I mean, that's what we do as far as disability goes.
I wanted you to address for a minute some of the policies at the federal level that have affected disasters in Texas. I know in the Obama administration there was the development of the disability integration specialist. So I was hoping you could just speak for a second about what the idea behind those positions are and kind of what our kind of position on their utility is, as well as what does FEMA do or not do or should they be doing to identify that a person has a disability, may need an accommodation, et cetera.
Right, and I think what we saw, and I think I know individuals have personal experience that were here in Houston, and at the time to sign up to get assistance from FEMA as quickly as possible. But in their application, it's not clear. They don't say, do you have a disability? Do you need a reasonable accommodation? Do you need any kind of assistance? That's not the process that's in place. And we heard from a lot of individuals that did not respond to what FEMA thought was their question about disability, and so they had to go back in, and I think our staff were quite involved in trying to go back in and to revise their application to say they were going to be needing some accommodation. So there's work at FEMA. One of the good things, as Dustin pointed out, is there are disability integration specialists, or there has been during this effort, and at a national level, there's been a lot of work together with all the states that were impacted by these storms to talk about how people with disabilities are being served, and through the disability integration specialists. Now, some of the issues with the disability integration specialists is we saw them come and go out of Texas. I'm sure you all saw that or some of you that might have been working in the area in Florida and some of the other communities. Some were placed for a short time and then they were moved. But then they did go on, FEMA went on to hire local individuals, and in the experience that at least I've had with those disability integration specialists, they've been very qualified people that understand disability and understand what some of the issues are. The individuals that I worked with in the Austin area that were working at the state office as a response in FEMA, they did understand disability and they did understand some of the challenges. The problem they had was within, or is within, FEMA itself, in that they would have staff meetings, and the stories they would tell us is they would come together with the regular FEMA staff or the staff that were on the ground, and that those individuals, the FEMA staff would come in and be very excited at how they had helped a person with a disability and had them entered into a nursing home, and now they were going to be taken care of. And the disability integration specialist was like, well, were they in a nursing home in a different area that was impacted? Oh, no, they were living in a house, but now they're in a nursing home and they're safe. Well, that person never wanted to go into the nursing home. It was what the FEMA person thought when they saw a person using a wheelchair. Oh, they need to be in a nursing home. And so the person, I mean, as you all know, during the disaster, sometimes the rights are eliminated, unfortunately, and that's where all of you and our staff come in to help individuals now find their way back. So the concept of the disability integration specialist is great, and I think it's needed, and I hope it's going to continue. I think there's some questions about whether or not FEMA will continue that, but it does provide for advocates within FEMA. Unfortunately, they're not necessarily always welcome, and they're by the individuals that have been in FEMA and may have more of a paternalistic attitude, are there with their set way of doing things. And they don't like to be criticized, as they're saying, they feel like they're being criticized by these disability integration specialists. So there's a lot of work that needs to be done and a lot of things going forward.
Thank you.
And you can probably give more as far as what the FEMA application looked like.
Well, I think, thank you for that, Jean. I
Yeah.
think one of the things that we found is that the existence of specialized staff for people with disabilities can be helpful, though the degree to which it's helpful varies in different cases, right? And so just know that if you're working with any person with a disability and part of what you're working on is a FEMA denial or challenge, if you haven't yet tried to speak with a disability integration specialist, that can be worth doing. FEMA does such a poor job of identifying persons with disabilities that it's not that they're already assigned a preset caseload. So it really is when someone advocates for someone to be on the radar of the disability integration specialist, that team with a specialized caseload may be involved to help them navigate their challenges. And we have, in some cases, seen those individuals just get involved in looking at even appeals for issues that don't seem tightly disability related. And so I think if you have a person with a disability in a bad situation and you've got a FEMA issue, it's worth trying that avenue. So I want to switch gears a little bit here and move on to my colleague, Jennifer. So Jennifer works on ADA accommodation issues, and I've asked her to talk about housing primarily and some of what we see as disability-related issues that come up in housing. But many of the principles she's going to talk about of your right to accommodation and your ability to file complaints if a person's discriminated against based on disability apply equally to every other kind of public accommodation, including FEMA itself. And so one of the things that we've done in a case where we were disappointed in the result of a FEMA appeal is we are actually filing a disability discrimination complaint with the Department of Justice against FEMA themselves. And so that's, these rights that people with disabilities have under the ADA apply against private landlords as well as, of course, state and federal entities as well.
So I cover housing largely, although my team does do a lot of other ADA issues. My housing work also encompasses the Fair Housing Act, which won't apply to FEMA necessarily, except when they're providing shelters, emergency, temporary, or otherwise. So let me get the hang of this really quick. There we go. Yeah. All right. So the mission of Disability Rights Texas, we kind of went over that already, so for your edification. But basically, when a disaster hits, there are issues of rescue, assistance, and shelters under the ADA. Particularly with Harvey, we saw just some examples of things that happened while Harvey was going on. When individuals with service animal were rescued, they were told they had to leave their service animal. I'm sorry, that's like telling someone who uses a wheelchair that they have to leave their wheelchair or their prosthetic leg, yes, sorry. So those sorts of issues are problematic. Then they get to the shelter, and maybe they made it onto a rescue boat that took their service animal, so they get to the shelter, and they're told, you can't be here with a dog. Sorry, we can't help you. Oftentimes, that can provide some serious issues, and that's just a tiny microcosm of the issues that people with disabilities experience. But the ADA Title II applies to the people providing shelter, to the people providing rescue, although it's very difficult to apply it to somebody on a boat who, came from the Red Cross to help rescue you from your house. They do need to accommodate people with disabilities. Even the American Red Cross, even in an emergency, it applies. And if they're telling the person they can't stay at a shelter, you guys need to come in and advocate. Yes, they can stay here, and you can't kick them out just because they have a wheelchair in your shelter has carpet and you're afraid it's going to tear up your carpet, or because they have a service animal and you don't want an animal in the shelter. With regard to temporary housing, FEMA can provide accessible trailers, turns out, but you have to ask for them. And FEMA won't just come up with, the question that FEMA asks, what was it, Taft?
They ask if you have a transportation need, a medical, dental need, a funeral need. But if you answer no to all those questions, they assume you don't have a disability.
Yeah, they don't ask, do you have a disability or do you need a reasonable accommodation of some kind? They ask you all these sort of vague questions that all combined, they say, means you don't have a disability if you say no. So you answer all those questions. No, they don't ask you, do you need a house with a ramp, or do you need a wheelchair accessible bathroom, or something like that. They ask you all these strangely vague questions, and then they say, nope, this person doesn't have a disability, they're fine. They give you a regular trailer, maybe from the state of Texas, and they come back a month later to check and make sure that you're using the resources that they've allocated at great expense to FEMA, and they find that you're still living in your swamp of a house with the roof caving in on top of you, and they don't ask you why. Why are you still living in the swamp? They ask you, have you used it? You say no, and they say, okay, we're taking it. And the reason you don't live in the trailer up on the cinder blocks is because it's got 4 steps to get in, and you use a wheelchair. These are the sorts of issues we have seen, and they can be easily addressed sometimes if you just tell FEMA what's going on, ask them for an accommodation, say this person has a disability, they need an accessible trailer. This person has a disability, they need accessible hotels for that temporary housing assistance. This person has a disability, they need any number of things. With regards to education, Dustin can probably speak more knowledgeably to that, but they need to be able to stay in their school district for their child with a disability. Maybe not physically, but they need to be able to bus the child. I think I've exhausted this slide, but basically under the ADA, you can ask for anything that's reasonable, so it's not a programmatic change and it's not fiscally an undue burden financially, but as long as it falls within reasonable, which, like I just outlined, is financially available or not financially undue burden, and not a programmatic change. So you can't ask FEMA to build you a house. They don't do that, but you can ask them to provide you with an accessible trailer, if that makes sense. And then after the disaster rolls out and the rescue is over and people are slowly transitioning back out of shelters, we have a housing disaster because the accessible housing is disproportionately affected. A lot of times it's first floor apartments, it's single-story homes, it's things that are not raised up and survive a flood, generally speaking. And a lot of times, low-income, affordable housing, which is what Jean sort of outlined for you as the general need in the disability community, tends to be under some disrepair in the first place. You throw a hurricane through there, and the roof caves in, the wall leaks, the ramp collapses, and the accessible housing is inaccessible now. A lot of times, landlords will evict to make reasonable repairs, and they are actually entitled under the Fair Housing Act and a lot of leases to do so. If that happens in your area, definitely go back to the lease. They are bound by contract law. If the lease says they have to give you 10 days notice before evicting you, they have to give you 10 days notice, even in an emergency. There's usually a provision in the lease that says for emergency repairs, they have to give you this amount of notice. Make them stick to it. Sometimes landlords will come in and say, you have to get out today because the flood happened, the sewage backed up, the fire, whatever. And the person is like, oh, the fire just took out my toaster. It didn't actually take out the whole apartment. I want to stay for a few more days so I can get my stuff together and find a place to go that's not a nursing home, not an institution. And you can hold them to that, to the contract matter, or in different states, there's different outlines for that. I believe in Texas it's 3 days. Some contracts will extend that to 5 or 10 days. So definitely be aware of that. I'm sorry, I don't know what Florida's is, but I would assume it's probably 3 days as well. Sadly, most of these states aren't really great in the housing realm. Reasonable accommodations during repair, you can possibly use reasonable accommodations to prevent eviction or termination. So if they have to fix the issue, maybe it's an issue that can be fixed in one room while the person continues to live in the apartment. Maybe it's an issue that can be fixed more quickly So they're maybe renovating the entire apartment complex first floor because it all flooded, but you can say, as a reasonable accommodation, can you make sure that mine is on the top of the list and mine is fixed first so that I can get moved back in because there's nowhere else for this person to go. And you could potentially, and again, this is sort of spitballing, reasonable accommodations, you can ask for it. It never hurts to ask. You could potentially ask that they not terminate the contract entirely, but just remove the person for the period of time it takes to fix the repair, and then let the person move back in. Here, a lot of people were just terminating entirely. The 2100 facility, it was, how many floors was that? Quite a few floors. It was a high-rise apartment or a mid-rise apartment, and they evicted everyone, despite the fact that the majority of the apartments were unaffected. There was some problem with the electrical system, and they didn't just evict them for however long it takes to fix the issue, they evicted them permanently. And that is something that we're exploring as reasonable accommodation. Could we have prevented that, or could that be prevented with a reasonable accommodation? You also want to ensure that repairs maintain or improve accessibility. I did see several apartments come in and say, well, the whole first floor was flooded. We're going to fix it. We're going to get our FEMA money. We're going to get our insurance money. We're going to fix it. And when they fixed it, they added in steps. They raised countertops so people in a wheelchair couldn't get there. They didn't maintain the wheelchair accessible bathroom that they'd had installed 10 years ago. They ripped it out and put in a regular bathroom because that's what FEMA paid for, or that's what the insurance covered. They need to maintain or improve accessibility. Generally speaking, you want to try to ensure that. Again, that's sometimes pushing it. They might say, well, that's an undue financial burden, but it's something to push for, especially if it was accessible to begin with. They are, under the Fair Housing Act, required to maintain a certain amount of accessibility and not backslide. We kind of talked about notice requirements. It's also possible to get a reasonable accommodation for more time to move. Like I said, there's that person maybe who is okay with moving out, wants the repairs done, but they need time to find somewhere to go in the meantime because they don't want to go to a hotel, they're too expensive, and they're living on the $750 a month. And they don't want to go into an institution like a nursing home because, well, I don't know if you guys are aware, but many times once people go in, they never come back out. They're kind of black holes in there. So, and it's scary to a person with a disability to be institutionalized. It's uncomfortable and it's scary, and it's definitely not what we want, and generally not what they want either. Housing recovery, continuing. FHA applies to shelters. The Fair Housing Act applies to long-term and short-term shelters, as long as the person basically calls it home. If they're leaving their belongings there, if they're coming back to it day after day. There's case law that has been found to support applying the Fair Housing Act to the Salvation Army shelters. So if a shelter or a housing provider is telling you, oh, the Fair Housing Act doesn't apply to me, they're probably wrong. Unless they only own that one house as a rental, they probably fall under the Fair Housing Act. Definitely look into it. Definitely it would apply to long-term disaster recovery shelters. And then back to Jean's point about a long-term plan. Like I said at the beginning of this, generally accessible housing is some of the hardest hit. It's on the first floor, it's low-lying, it's sometimes in already some disrepair, so it's more susceptible to roof leaks, wall leaks, things like that. It would really be helpful, it would be ideal if we could get the state and local governments to create a long-term plan to maintain housing for people with disabilities before, during, and after a disaster, because it's during and after the disaster that the person is most vulnerable in a disaster situation to being institutionalized, because there is no other accessible housing. So if state and local governments would increase their stock of accessible housing, that would go a long way towards maintaining people's independence. And us as advocates and other nonprofit agencies should be holding our policymakers accountable. Way before Harvey hit, we should have been saying, and I know it's hindsight's 2020, but we should have been saying, what are you gonna do when this happens? Because it's not if, it's when. You guys, Florida and Texas, you both know, it's not if, it's when. So we need to hold them accountable. As my father-in-law says, and I apologize for the crude language, but stick to the 6 Ps. Prior preparation prevents poor performance. So if you prepare in advance, you can ensure that people are able to maintain or find affordable, accessible housing. And just generally, I don't know if you guys are familiar with the Fair Housing Act, but there's a joint statement from the Department of Housing and Urban Development and the DOJ about reasonable accommodations. If you Google it, it will come out, I promise you. If you can't find it, you can email me. I believe my email will be made available to you, or you can call Disability Rights and I will give you the link. And there's a joint statement on reasonable modifications. Now, the difference between accommodations and modifications. Accommodations is a programmatic change, a policy, a rule, a procedure. I need you to allow a service animal into the pool area. I need you to allow me to pay my rent on the 3rd when my disability check comes in instead of on the 1st. That's a programmatic change. A modification would be anything structural. I need my doorway widened, I need my bathtub accessible, I need a ramp, something like that. So if you've got questions, those are great resources. Check them out.
So with individual landlords, when you see disability issues come up that are discrimination or common needs for accommodation, what's usually the first step in kind of handling that issue for a client, and then kind of the next step if the landlord's not responsive?
So outside of disaster recovery, my first step would be to just ask for the reasonable accommodation. Even if my client's asked already, I usually put it in writing. Paper trail, always, document, 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 because HUD, the rule is you don't have to put it in writing, but if you don't put it in writing, there's no proof that you asked. So make a reasonable accommodation request in writing. I usually sort of outline the law briefly and simply for them. I believe there's an example reasonable accommodation request on HUD's website. And then if they refuse or make some excuse or say the Fair Housing Act doesn't apply to me, you can always file a HUD complaint. Sometimes there's retaliation after you ask for a reasonable accommodation. They'll come up with a reason to evict your client. Again, that's a HUD complaint, and that's why you need the paper trail, because you can show retaliation usually. And then the HUD will investigate, and I haven't had a whole lot of luck in Texas, but hopefully Florida's a little better. But that's why you need to document everything thoroughly so that the housing provider can't come back and say, oh, they didn't ask, or they didn't ask. There's no right way to ask, but they might try to say, oh, it wasn't clear to me what they were asking for. Be very clear, make it in writing, document, and then you can file a HUD complaint if they deny.
Thank you, Jennifer.
Mm-hmm.
So Jennifer made a quick mention of kind of my area of specialization, which we don't have another person on the panel for, which is education. And you know, when everyone filled out the forms of what you most needed to learn, I was really sad that no one mentioned education. And I think it's because you don't know how cool education is. And what I mean by that is Disability Rights Texas in a way is unique because we are the only legal service provider in this area that provides education advocacy. And so I think a lot of times when people are in a storm, if they're talking to someone who's not specifically asking them the questions about how school's going, you may not learn what a train wreck is going on at school. Myself, my husband and I flooded. Our 5-year-old was in play therapy for 6 months as a result. We definitely had different behaviors after the storm. The kind of education-related disability issues we're seeing come to us are everything from they don't let me, if I've moved into a shelter situation, then I have a right, as I'm now McKinney-Vento eligible, which means I'm homeless, to stay in the same school I was at, even if now I'm 30 miles away, and the schools have to pay to transport me there. So that's, you know, one thing to keep in mind that's an educational right. We love McKinney-Vento cases at our office. Also, in special education, we have people who are going to have temporary behavioral challenges or needs related to having experienced the disaster, and we'll have a smaller subset of people who may have long-lasting trauma and accommodation-related needs because of having experienced the disaster. And so we have had cases of expulsions for things that we thought were kind of trauma-related, and we're helping those families, people who need more positive interventions, counseling, et cetera, at school, and we're using special ed law to advocate for those families. So no, that is something that you can refer to Disability Rights Texas. Another thing is, for those families who it doesn't make sense to stay in the same school, The more complex your child is, the more complicated transferring schools to a new area is. So, we've had a number of cases where I have a medically complex child, I'm now living in a new area, the nurse doesn't know what she's doing at the school, my kid's coming home ill, and so those are also issues that you can refer to our office. Now to kind of transition specifically into healthcare, my colleague Taft, who works full-time on our hurricane project and whose background is in health law, is going to give us some of the overview of what to keep in mind about health-related issues for folks with disabilities in storms.
Hi. So as they mentioned, a lot of times in a storm, individuals who they can't figure out what else to do with them, or there's no one else to take care of them, and they have disabilities that, they don't know what to do with them. A lot of times they end up institutionalized. It happens in every disaster, no matter, they say it doesn't happen, it happens. We're doing research now looking into individuals who have been institutionalized since Harvey. But there are ways to prevent that from happening. We have waivers. Let me click this. We have Medicaid waivers. And Medicaid waivers they give the state some flexibility on what they want to use their money for, and they're not as restrictive as just traditional Medicaid. And I did look up, Florida has some waiver programs too, and so every state has them. They may not be exactly the same or named exactly the same, but the states each have them. So those home-based programs that keep people in the community allow them to get the same care they would get in a facility, but they get it in the community. It's less restrictive. Their family can keep them, or they can live in a smaller setting to where they're, it's more intimate as opposed to being in an institution, a large institution. Community integration is upheld in Americans with Disabilities Act, ADA integration mandate, Supreme Court Olmstead decision, and they want it to be the least restrictive environment for individuals with disabilities. So one of the waiver programs is the home and community-based services waivers. And the Medicaid home and community-based service waivers afford states the flexibility to develop and implement creative alternatives to placing Medicaid-eligible individuals in hospitals, nursing homes, or intermediate care facilities for persons with ID and DD or related conditions. Okay, so I didn't go into a lot of depth about each of the waiver programs because I know we have people from Florida, so I did put the website for you to look up each of the waiver programs for your state. I put it on the slide, so you can just look those up and get the most relevant information for your state. But know that those waiver programs are available, and they should be used as an alternative to placing individuals in nursing homes. Another thing that I do is I help people who need to do a Medicaid appeal. I assist them either if they have been denied services, DME, or if they're being denied eligibility. Something that Texas is facing right now is a lot of children that are on MDCP, which is for medically fragile children. A lot of them are being taken off, whereas they've made eligibility in the last 10 years, but this year they're not eligible anymore. There have been a lot of cutbacks, and so these children are coming in the hundreds for appeals because their parents don't know what to do. They've never had to actually deal with a Medicaid appeal before. And theirs is based on their medical need. So one of the things about a Medicaid appeal is they have to give you notice. Notice is a letter that you've either been approved or you've been denied, and they have to tell you why you've been denied if you get a Medicaid denial. A lot of times parents don't know that they're entitled to this notice, and it gives them a certain amount of time. I know in Texas it's 10 days to be able to call and either request an appeal, an internal appeal, or a fair hearing. And if they do that, they get to keep continued services throughout the time until the decision is made at the very end. If they don't do that, they can still appeal, but they won't have the continued services, which means their child loses the medical coverage that they so desperately need until the hearing is over, which causes a problem. They have to rush through it. They don't take the time they need to gather all the information because they don't want their child to be without the Medicaid even longer than they already are. And a lot of times, the hearings officers can take up to 90 days to make their decision. So you've waited months to get to this fair hearing, and now you have to wait another almost 90 days sometimes for a decision. So your child could be without their medical care for, 6 months. So when someone calls and says they need assistance with a Medicaid or any type of Medicaid appeal, whether it's DME, it's services, or it's eligibility, you treat it as you would any other case. You start to gather your evidence. A lot of times it's medical records, letters of support from physicians, and it's Texas TMHP here, but the state has to give you their evidence they plan on using in the fair hearing. So they're entitled to it. They can call and request it, and they are entitled to it before they go to fair hearing. They're entitled to their whole entire case file. So a lot of times you'll find all the answers that you're looking for as like what you are trying to rebut is in that fair hearing. What we see a lot of times is decisions are made based on what they have, not what they should have gathered. They didn't ask for additional information from the doctor. They didn't ask for letters of medical support. Whatever was sent in is what they make their decision on. So many times they're making their decision with half of the information, if even that. And so what we do is we gather a well-written letter of medical necessity. We gather medical records, and then we gather information about whatever it is they're needing, whether it's a wheelchair, or it's a medication, or it's a service, nursing, or it's a way that they should be entitled to be eligible for the waiver program that they're applying for. So these are just the basics about Medicaid hearings. They are conducted by a hearings officer. They are not an attorney. There's not evidence. There's no evidentiary rules. Basically, everything that you bring comes in. The hearings officer is in charge of conducting the hearing. A lot of times the hearing can be a couple of hours long. It's just like in court. The state gives their testimony first, and then the appellant will give their testimony. If they have an attorney, the attorney will, ask questions, cross-examination questions of the state, and then direct questions to their client. Or if they have, a nurse that the client uses, they'll, witnesses. The agency has the burden of proof. Sometimes you question that, but they're supposed to have the burden of proof. So they're supposed to prove that your client it's not medically necessary that your client has this service or this DME. So really, you shouldn't have to put any evidence, but you do, because if you don't, I've seen parents go in with nothing, and 95% of the time they walk out without whatever service they went in for. Let's see. Oh, and I guess that's it. So basically, you do the fair hearing. The hearings officer listens to both sides. You do a closing statement, and then the hearings officer will take all of the information, make a decision, send the decision in writing, and if you want to appeal that, you can do an administrative review, and that will have someone else look at the case, and if they see that there's new information that you sent in, they will reopen the fair hearing, or they can make a decision based on what you sent in. And then if that is also denied, then you do a judicial review, which then you go to federal court. So, but yeah, that's what so during Harvey, I've done MDCP fair hearings. I've done DME fair hearings. A lot of times FEMA will deny DME requests for canes, wheelchairs that were lost. They'll say that they need to get it through their insurance. Medicaid, Medicare. Medicaid only pays for a wheelchair every 5 years. So if they just recently got their wheelchair and now it's destroyed, they're gonna have to appeal it and they're gonna have to fight to get that wheelchair. They're gonna have to fight to get whatever it is they lost if it's not within a time frame that Medicaid is okay with paying for it again and prove that they need it. So that's some of the things that we're seeing, and MDCP is an ongoing thing, and so individuals were dealing with MDCP appeals during the time that they were displaced, living in a hotel, not getting their notices, and so they were being denied their services, and they were having to appeal the fact that their appeal was dismissed because they didn't get any of their paperwork. So it's been an ongoing issue. Medicaid is not an easy thing, and they don't care about what you have going on outside of that. So.
Thank you, Taft. So this was just a sample of kind of overview issues of what we're seeing most, but I want to open it up for any questions, and we're fair game on anything for a person with a disability or related to disability-related issues. So Lauren, I know your name.
Yes, I have a question regarding FEMA appeals. Thank you. I have a question regarding FEMA appeals. So we have received numerous appeal needs, many of which the individual did not appeal within their 60-day time frame. There's a variety of reasons, but in some cases, I honestly believe there was a lack of understanding or a reasonable attempt to appeal by someone who, at least in my opinion, may have been a person with some kind of cognitive disability that prevented them from being able to articulate their appeal or effectuate an appeal. How do you best articulate some kind of reasonable accommodation need in that context? Like FEMA should allow them a reasonable accommodation to apply past the 60 days because they need it for X disability.
So I hear two things in the question. The first thing I hear is we need some clarity around whether the person's comfortable making a claim that they have a disability and need an accommodation, right? And so, you're detecting that I suspect that this person I'm serving has a disability, but it seems like the person may not be using their words to tell you that. And I think sometimes if you don't live in the disability space, people are kind of on edge about, is this something I can ask about? Is this something we can talk about? And I would say it is. Like, if you don't make it weird, it doesn't have to be, right? And so, I think the first thing is just like, let's clarify that we're working with a person who has a disability and what it might be, and that we're gonna own this argument that there's an accommodation. One way that I might just introduce that concept into the client communication is, okay, unfortunately, we missed the standard deadline. I know it's ridiculous. For some of our clients, we've been able to argue that there should be an accommodation because they didn't know about the deadline because they have a learning disability or they have an intellectual disability, and just kind of plant that seed that that's something that you're seeing with other people. Do you have anything like that that might help us in making an argument for an extension of the deadline, right? And you can ask some concrete questions that get to disability. Is when you were in school, did you ever receive special education services? Of course, other people have later disabilities. On this project, we have individuals who had strokes, and so they had cognitive impairments that were after the age of 18. And so ask those questions and kind of firm up. We're going to make a claim that's disability-based. And I think when you're writing that request for an accommodation, you don't want to be timid about it. I'm representing so-and-so who's an individual with a disability. She had a stroke last year and she has a cognitive impairment. As a result, she's no longer able to read and comprehend her mail. She did not receive any accommodations from FEMA in the information that was sent to her. As a reasonable accommodation, we expect you to accept this appeal beyond the deadline. I'll say, I think across the board in our agency's FEMA appeals, we're seeing a real mixed bag. We're successful on some we didn't expect to be successful on, others that we thought were pretty good. We haven't been, so we are filing a DOJ complaint in one we were disappointed in the result of. We've gone to the media in one that we were disappointed in the result of. But I think that there's never really a reason to be shy about putting that request for accommodation out there, in part because it is articulating clearly to the other side a new line of argument that you may have and a new kind of complaint that you may file, and that alone may get some additional attention. Did that answer your question, Laura?
Can I say something?
Yes.
So I've done, none of our people's appeals have been before 60 days. Let me just tell you, none of them, okay? So.
We've never done a timely appeal.
No.
We've never done it.
But that is not the denial that we get in response to our appeal, because we basically ask them to base their appeal on the merits of the case and not the timeliness of the case of their appeal, because they do have a disability, and I have not gotten any returns or rejections for any of my appeals.
Based on the timeliness issue.
Based on saying that it should be based on the merits, not the timeliness.
And I'm sure y'all are doing this too, but I know one thing that Taft and others at our office have done is just filing another one. And when I myself was at a disaster recovery center in my neighborhood after the flood, the woman who was in line in front of me was just giving practical tips to another person in line, and she said, "It's the fifth appeal that always wins, so just keep doing them. It's the fifth one." And I thought that was funny, just like street side advice, but I don't know that she's wrong.
Oh.
I think don't accept no for an answer.
The other thing that I was told is that even if it says final denial, I was told by FEMA, send another appeal. So, yes, keep sending them.
Just paper them, just
To
document.
death.
Another thing that you can ask for an accommodation for, as a side note, is if your client was incapacitated for a period of time during their appeal. So maybe they have a disability that ended up hospitalizing them for a short period of time, but it's not one that incapacitates them permanently. Maybe they have a seizure disorder or a mental illness issue that they needed to get under control, and so they were in the hospital for a week or something. You can say they didn't have the full time to appeal because they were hospitalized for a short period of time. And I know that works in the housing context. Haven't tried it with FEMA.
It does work.
Definitely worth a shot.
It does work. So I sent it in to FEMA, and it was well beyond its time, and I actually got it approved. So, and it was for transportation.
Other questions?
I actually have two questions. Have you had any success for certain DMEs where, say I have a client who has to use a specific wheelchair, and he was originally told to go back through Medicaid. Medicaid will not compensate for the specific wheelchair, and so now I have to go through this whole process of trying to get enough money to get that part covered, and it's becoming a huge issue.
What's Medicaid's reason for denying it?
I'm not quite sure. I just got this case, and so I'm meeting with him next week, and that was his main concern, was for some reason they will only compensate for one type and not the type he needs, and it's the type he currently has.
Okay, well, if you can, I would do it. Ask for an appeal.
Okay.
They can do an internal appeal, but you don't have to have the internal appeal before you go straight to the fair hearing. And then prior to the fair hearing, you send them all of the documentation that supports the fact that he needs this particular one, like a letter from his doctor, medical records. Your best bet is to go through Medicaid and appeal it, not to do FEMA or raise. If you can get Medicaid, unless we've even had people, they've said it's not a covered benefit, and we've gotten it covered.
Okay.
If you can prove that it's medically necessary for them to have the specific DME.
Okay, and then my second question was kind of regarding, I don't know if y'all have had any success with obtaining some temporary guardianship for ownership purposes with FEMA, if y'all have dealt with anything like that, or if...
So this is another one where we have strong values. So like, we see ourselves as a civil rights organization for people with disabilities, and guardianship is the legal process by which we strip people of their civil rights. So we just don't do it ever. So I know that there are perhaps good reasons that in some situations you may have to consider that, but that's not something we're ever going to do. So for us, we're always going to look at what are the less restrictive alternatives to guardianship. One thing that's really unique about Texas is we're the first state in the country to have a supported decision-making statute that allows a higher number of people without disabilities to use less restrictive alternatives to guardianship. There's a lot of information about that on our website and videos and supporteddecisionmaking.org. But you know, for people with really significant disabilities, there may be some more challenges there. We're always happy to help problem solve challenges that could lead people to take away the rights of someone when it doesn't need done. I think one thing to be careful of, if you do end up needing to do a temporary guardianship because there really isn't an alternative in the individual situation, always making sure that the guardianship is as limited as possible. The easy example there is like, guardianships are supposed to be as limited as the doctor recommends to the court and the court finds as necessary, but in Texas, over 90% of guardianships are full guardianships that even take away the right to vote. So it's, you know, difficult to show that a person with a disability can do any worse job voting than anyone else. And so, you know, because of that, I mean, to me, that's the easy example of like, if you find yourself having to get a temporary guardianship, make sure that the process of reviewing that application, even by the doctor who's kind of signing off on the form, isn't a rubber stamp. They're being thoughtful and only taking away those rights that are really essential to help with that property dispute or whatever it is.
I was just going to insert one of my questions,
Yes.
if that's okay. I had worked in my health law clinic in law school and done administrative appeals. And one of the things that we did a lot of was every time you are going to do one, and maybe you could speak to this in Texas, but you know, you always want to submit something new, and in particular, the letter of medical necessity, and coaching the doctor through how their previous one that they just sort of, again, in that rubber stamp sense, like, you know,
You should
knocked
write
off
it.
or had. Right, and that's what I'm saying, coaching through what was
We send 'em a
deficient.
sample.
And, right, send a sample, and if you need to get more information out of them in order to beef it up, to really actually, even if you're annoying them, have a conversation with them. And I had a doctor chew me out one time and say, "You're wasting my time," and then he did it. And the person, as soon as you submit it, a lot of times they
overturn it.
They overturn before even having a case, because they've got that extra piece of, you know,
Oh, yeah.
thing that they can't really argue with once it's theirs.
The letter of medical necessity can almost make or break the case. And a lot of times doctors they need help brushing their teeth, they need help getting dressed. That's not going to get you into a waiver program, or, you know, that's not going to prove that you're medically fragile. But that's what they focus on. So what we do is we send them a sample letter that is tailored to the child, and we tell them to delete or omit whatever they don't, add whatever they want. Email us, tell us what else you want into it. Want in it, and then you can put it on your letterhead. And so that happens a lot, and it makes a huge difference.
And Taft, are you usually going through the social worker at the office, or who is it you're usually trying to get to help you practically in the office get that letter of medical necessity back?
Oh, it's usually their nurse or the front desk person. And so what I do is I request all their records first. I go through the records, I talk to their parent, find out all the information that I need to know about the person, and then I draft the letter based on that information and that doctor's medical documents, their records. And so I'm taking exactly what they had and just putting it in paper and adding, you know, the things that they need to see on that letter.
And this is sort of my little, for the nurses, I always like to sort of make sure I grease the wheels and like indicate that I am not in any way trying to find out there's malpractice or anything like that, because they're so lawyer shy in some ways. I always felt like, you know, they can get to the doctor and tell them that you are acting for the patient and not trying to look for something that they've done wrong.
I send a letter with it, and I let them know that we're doing a Medicaid fair hearing, and we would like to have your letter of support on what, what they need. And we send it, so they don't have any, well, we've only had one that thought that somebody was out to get them, but outside of that, I've never had an issue.
During disasters, you have a lot of private people stepping up for like emergency rescue or providing private shelter. What rights and protections do people with disabilities have against private individuals who step up to help? Like, let's say the person comes around with their fishing boat and they don't want to take the service animal. Like,
So if it's just a rogue and a rogue good Samaritan, then really none. If the volunteer is affiliated with an organization that employs staff, then it's different. The other thing is, I can't say, certainly in the days right after the disaster, when some of our staff were in shelters and trying to assist people, those were issues we tried to problem solve, and in our planning, policy advocacy, making sure shelters have good policies and other service organizations. At this point, we're all focused on recovery, right? And so the average case that we're working on is, trying to get people into decent housing and addressing those longer term needs. But the Good Samaritan volunteer, there's really nothing that would require them to accommodate. I will say that what I've personally experienced among Good Samaritan volunteers is a lack of knowledge more than like an impetus to discriminate. So it's like the assumption that we're not going to talk to the person with a disability, the not knowing kind of best practices around community-based services instead of institutions. It's those issues I think we see most with volunteers compared to, kind of a desire to discriminate. So, I don't consider either of those to be community. So the gold standard in the disability rights movement is really, letting people live in integrated housing, which means you're all alongside people without disabilities. Now, another kind of principle we would have in our movement is around self-determination and what people really want, but it's not what someone wants when they're not presented with real options, right? And so, like, if you have a person who's in a disaster situation and you present them with a nursing home only, and they're not told about the ability to have a nurse come into their house and provide services in a place that they choose, well, to me, that's not, if you just ask them, well, do you want to be here? Well, where else am I going to go, I guess? So that's not real choice. Now, there are people, and it's a minority of them, but there are individuals we found in nursing homes that are like, no, I really do want to be here. And of course, we respect that choice. So it's about making sure that our clients understand their options and can make an informed choice and receive the support to live in their preferred living situation, which is usually integrated housing. And so for most people. No, we can have a new disability that's expected to last for a period of time. So, so I do a lot of kids cases. So we've seen, even in the immediate aftermath of the storm, children receive a diagnosis of a transient trauma and anxiety, with anxiety features or whatever kind of diagnosis. And then later, we've now seen more kids who are getting kind of longer term PTSD type diagnosis that can be a basis of requesting services. Of course, unfortunately, I think that mental health aspect of recovery is kind of a low priority for many people, and so they haven't yet gone and receive that diagnosis. Now, one thing to keep in mind is if the child is school age and we're seeing these needs appear in a school-based setting, the responsibility to potentially evaluate, identify, and serve falls on the school, not on the family. So in other settings where you're requesting an accommodation, that entity may be able to say, show me your documentation of a disability. But if this is appearing in a school setting, the family just needs to know that I have reason to suspect that this child may have disability-related needs in a school setting, and request evaluation in writing based on that. Any other?
One more in the back. We're short on time, so I want to get everybody.
Just
quickly, would you agree or disagree that, say, as an fair housing issue, that a landlord who, prior to a disaster, does not allow pets is not obligated to now accept a pet just because someone is presented to him with a disability looking for accommodations?
Disagree.
As long as they don't, as long as it's not discriminatory, and that's just.
It is discriminatory.
It is discriminatory. So
No, what if it's their policy that they just don't
It's a
allow
discriminatory
pets?
policy.
discriminatory policy. So under the Fair Housing Act, with regards to service or emotional support animals in the housing context specifically, so the animal doesn't even have to perform a service as long as it is prescribed by a doctor essentially, or a social worker, or a nurse, or someone with someone in a position to know that the person needs this emotional support animal, therapist, anybody like that. Then they can make a reasonable accommodation to the landlord, and that would be a waiver of a policy, practice, rule, anything like that, to allow them to keep and maintain either a service animal or an emotional support animal. They can't charge for a pet deposit. They can, on the back end, charge if the pet does destroy the blinds or something, but they can't charge in advance, and they can't bar them based on even a flat non-discriminatory on its face policy, because if the person has a disability that requires them to keep either a service or an emotional support animal, they have to allow that.
I think the thing to keep in mind that's like an overarching concept in disability is when we talk about disability-related accommodation, in other areas, people might think of discrimination as treating someone differently because of whatever category it is. In disability, you have an active right to reasonable accommodations. So reasonable accommodations are treating someone differently because of their disability, and that's a right you have. So failing to reasonably accommodate a person with a disability is disability discrimination. So when we're talking about the issues of disability discrimination, we're not asking to be treated like everyone else. We're asking for reasonable accommodations for our disability-related needs, and that's true whether we're talking about housing or in a restaurant. Every restaurant in Houston says you can't bring your dog inside. I mean, that's a policy that they all had before the storm, they all have after the storm. That's a policy all restaurants have, and every single one of them has to let our service animals in, right? And so that's the nature of what disability kind of law says. It's treating people differently according to their disability.
Okay, and then just as a piggyback to that, if, say, one potential renter, I'm charging them for pets, but then you're telling me that I don't have to do it for someone with a disability, is that still?
It's not their pet, though.
It's not a pet. It would be a service or emotional support animal, commonly referred to as an assistance animal, covers both categories. And there's more, there's a DOJ HUD joint statement on that as well. No, it's an FHGO notice on that I can give you some information
And the answer is can't charge.
Can't charge. If they ask for reasonable accommodation, you've been notified that it is a support animal, can't charge.
We heard examples right after the storm of people with disabilities being asked for higher deposits, as a way of discouraging them from renting in the building, and that's also not allowed, right?
Right.
So anyhow, I think we're at the end of our time, so I thank you all for your attention. I would just end with, keep the number that I provided at the beginning of our presentation. We're always happy to receive referrals on disability-related issues from this network. We're staff tough cases. If you have kind of more detailed training-related needs on a disability-related topic, feel free to reach out about that as well. And it's a pleasure to get to know you all.